as the first case. Item 1, WPC 5781 of 2016.
They are seeking adjournment.
Well, Mr. Rahul Gupta is reading. Any day next week.
You objected? They must have informed you.
Yes. Yesterday. Next Friday is reference. If Thursday, if it is convenient, we will also.
Thursday is not convenient. Wednesday we have these first appeals and second appeals. No?
Or Friday, if my can be taken as first case. There is reference on Friday.
Yes. On 4th we will take it up in the first half itself. 10:30. WPC number 5781 of 2016. The learned counsel for the parties are present. This court has been informed in advance that the respondents would be seeking adjournment in this case on account of personal difficulty of their arguing counsel, namely Mr. Ram Kumar Gupta. Counsel for the petitioner has no objection to the prayer for adjournment at the request of the counsel for the respondents. The matter is to be listed on 4th of July to be taken up at 10:30. 4th of April. जुलाई पहुंच गए. कुछ अगर मान लीजिए 4 तारीख को सैटरडे कभी किसी का पर्सनल अपीयरेंस होता है रेयरली, तो वो थोड़ा एक आध मैटर करके फिर 4:30 बजे सुनो, मतलब 10:30 बजे सुनो. ठीक है. 10:30 इसको आप खत्म करना है ना, इसको नहीं आप पेंडिंग कर सकते हैं. फिर मेमोरी ऐसा लॉस नहीं होगी. उस दिन उन्होंने सारा ही अपना रिटन सबमिशंस प्लेस कर दिया. आप भी उनके जो भी वो आर्गुमेंट किए हैं उसके बेसिस पे अपना रिटन नोट बना लें.
Well, in fact, we have made a chart since the principal argument of the petitioner was that there are overlapping wrongs which are there in the LPG control order and also in the LPG. We have prepared a chart which wrongs are covered in LPG but not covered in LPG.
तो ये चार्ट बहुत जरूरी है. Because उनको भी दे देंगे. They will have to respond to that.
We'll give an advance copy. We'll give it on Wednesday.
So your case is that you are not proceeding simultaneously.
Not proceeding. That's a criminal prosecution. We'll have
No, for the same
same wrong
thing.
we are not.
For the same wrong, we can have a departmental proceeding and a criminal proceeding also. But according to you, it is not the same wrong. There are different compartments, and you are proceeding accordingly.
In fact, we have found a Supreme Court judgment which categorically said, though it is unsettled law, that a particular wrong can be both a civil wrong as well as a criminal wrong.
तो आपके इनकम टैक्स में है.
Income tax. And in fact, Manoj are aware Guljar industry case.
Passover case, item 33, contempt 840 of 2020.
Payment has been made through online mode.
अभी हमसे बात हुई है तो हम ब्लॉक
SMS नहीं आया उनको.
SMS में ब्लॉक में वो खाता लेकर के ब्लॉक में उनको बुलाया गया है.
खाता लेकर के क्या चीज का खाता?
बैंक अकाउंट.
इनका पासबुक,
बैंक.
वो पासबुक में इनका अपडेट नहीं हुआ होगा.
अपडेट तो हो
अभी तो ऑनलाइन पेमेंट हो गया, अब क्या ही करना है.
ये तो बोल रहे हैं हम लोग. और ये जो दूसरी बात है ये फैमिली पेंशन अभी क्या उसका मामला थोड़ा देखा, इसको 2 वीक के लिए रख दिया जाता है उन्हें पेपर फाइनल. दिस इज वीडियो में
फैमिली पेंशन को तो भेज दिया गया.
भेज दिया गया.
अब तो फिर उसमें इनका अब कोई रोल नहीं है.
आई एम नॉट डिनाइंग दैट बट फॉर दिस
इनका स्टेटमेंट रिकॉर्ड कर देते हैं कि ऑनलाइन पेमेंट से इनको पेमेंट हो चुकी है. ठीक है. और ये जो डॉक्यूमेंट लगाए लगा, अगर मान लीजिए किसी कारणवश आपको पेमेंट नहीं हुआ है, यू इन्फॉर्म दिस कोर्ट, वी विल रिकॉल दैट ऑर्डर.
It was paid. Yes, this value shown in the column are written by page bank after DDO initiated the account verification circuit. कोई difficulty रहता है तो रिटर्न हो जाता है, but
but as per your मतलब जो भी है
GPF का जो मेजर अमाउंट है वो जो 1,04,000 समथिंग,
इसको सिंपली एडजस्ट कर दिया जाए, सो दैट हम इनका पासबुक जो अपडेटेड है वो भी दिखा देंगे, वो इनकैश में नहीं पता चलेगा।
आपको इन्फॉर्मेशन मिला है ना उनका
हाँ,
account
हमको
payment
इन्फॉर्मेशन
हो
एज पर दिस डॉक्यूमेंट।
देखिए कंटेंट सिविल 840 of 2024. The learned counsel for the opposite party has taken instructions and has produced certain documents to show that the amount has already been remitted in the account of the petitioner. He has also submitted that there is a caveat to it that in case of any difficulty, the amount is returned back. यही है ना?
हाँ,
But as per the documents, he submits that prima facie the amount has been remitted.
yes.
Counsel for the petitioner has submitted that he has आज ही के दिन में किए हैं
नहीं, वो
पहले ही कर दिए हैं.
पहले का है, कुछ पहले का है, कुछ ऑर्डर बने।
The learned counsel for the petitioner has submitted that he has no up-to-date instructions.
अभी तक का तो इंस्ट्रक्शन यही है, हम लोग के अकाउंट में नहीं गया है अभी। अभी उनको बुलाया गया है, वो जो ब्लॉक कंसर्न ऑफिस जो है ना वहाँ पर बुलाया गया है।
He has submitted that till now the amount has not been credited, and the petitioner has been called upon at the concerned office for some reason. कोई कारण से बुलाया गया होगा ना? Pose this case on Wednesday in the supplementary process. आप instruction लेके बताएं.
From the supplementary list, the reading for final is well item 1, 2nd April 21 of 2022.
With respect to the first substantial question of law, this court finds that the appellants are claiming title over the property. LC Aditya? By virtue of Exhibit D, which is admittedly an unregistered agreement of sale, wherein total consideration of the amount has been mentioned as 1 lakh, of the property has been mentioned as 1,05,000. And during the course of argument, it is not in dispute that as per the agreement and otherwise also, part payment has been made. It is further not in dispute that the appellants are in possession of the property and a suit for specific performance of the agreement is pending before the court.
Right now they are not in possession.
Sorry?
Right now they are not in possession.
Okay, okay. Uh, at the relevant point of time, they were in possession of the property and pursuant to the decree passed by the learned trial court,
Eviction.
in the eviction suit, they have been evicted. It is an admitted fact that a suit for specific performance of contract is pending.
Yes, which these respondents are not party.
You are not a party in specific performance.
No, he is party. I am not a party.
Acha, specific performance of suit is pending, in which the plaintiff of the present case is not a party. The agreement is dated 15/12/2003 within bracket exhibit D. It is further not in dispute that even as per the claim of the appellant, they were inducted as tenant in the premises way back in the year 1967-68, 66-67, and till the agreement of sale of the year 2003, there is nothing on, they have not claimed any title of the property. Correct? Now the moot question, in order to answer the substantial question number A, is whether the appellants have acquired any title over the property by virtue of part performance of the agreement of sale within bracket exhibit D dated 15/5/2003. ये डेट ही बार बार भूल जा रहे हैं 15/12/2003.
15/12/2003.
हाँ 15/12/2003. रजिस्ट्रेशन एक्ट लीजिए, ट्रांसफर प्रॉपर्टी एक्ट लीजिए. As per the provisions of section 17 within bracket 1 capital A of Transfer of Property Act of Registration Act 1908, it has been clearly, which has been inserted by Act 48 of 2001 with effect from 24/9/2001, it has been specifically provided that the documents containing contract to transfer for consideration any immovable property for the purposes of section 53 capital A of Transfer of Property Act 1882 shall be registered if they have been executed on or after the commencement of the registration and other related laws within bracket amendment bracket close Act 2001, and if such documents are not registered on or after such commencement, then they shall have no effect for the purposes of the said section 53 capital. Section 53 capital A of the Transfer of Property Act. Has also been simultaneously amended by Act 48 of 2001 with effect from 24/9/2001, wherein the word inverted comma, the contract, though required to be registered, comma, has not been registered, comma, or inverted comma, has been deleted. Which was earlier appearing in the aforesaid section 53 capital A of the Transfer of Property Act. The provision of section 53 capital A as it stood prior to amendment and after amendment, that is after 24/9/2001, is placed in a comparative table as follows. And the omitted portion with effect from 24/9/2001 has been placed under bold letters. Upon comparison of the provisions which was prior to 24/9/2001 under section 17 of the Registration Act and 53 capital A of Transfer of Property Act, pre and post amendment, this court finds that prior to 24/9/2001, in case there was any agreement of sale, though unregistered, and the party was put in possession of the property, and the conditions contained in section 53 capital A of the Transfer of Property Act 1882 was satisfied, the said person could not be evicted and had a right to retain the property and it was provided under section 53 capital A that the transferor or any person claiming under him shall be debarred from enforcing against the transferee and person claiming under him any right in respect of the property of which the transferee has taken or continued in possession, comma, other than a right expressly provided by the terms of the contract. It also had a rider that nothing in section 53 capital A shall affect the rights of a transferee for consideration who has no notice of the contract or the part performance thereof. This court finds that by virtue of the aforesaid amendments made in the two acts effective from 24/9/2001, any agreement of sale has to be necessarily registered in order to claim any benefit of part performance under section 53 capital A of the Transfer of Property Act. In the present case, the agreement of sale exhibit D having been executed after 24/9/2001, the same is inadmissible in evidence to give any benefit to the appellants of being in possession of the property in terms of section 53 capital A of Transfer of Property Act. In this connection, the Learned Counsel for the respondents has also indicated that the appellants have only made part payment and they were not in possession of the property by making by paying full consideration amount.
And has not taken any step in furtherance of the contract.
And therefore they have not taken any step in furtherance of the contract, for which he has relied upon the judgment passed by the Honorable Supreme Court in Ghanshyam versus Yogendra Rathi, reported in 2023 Live Law within bracket SC 479, and has referred to paragraph 9 thereof to submit that even the possessory right cannot be claimed by the appellants, as the payment that was made was only part payment. इसमें registered था कि नहीं था कुछ नहीं है ना. However, from the said judgment, it is not clear as to whether the agreement of sale was registered or not registered, and admittedly in the present case only part payment with respect to the sued property was made by the appellants, and they are claiming benefit of part performance of contract of agreement referable to section 53 capital A of Transfer of Property Act.
Land in connection with section 54 of the contract.
I'll come to that later. तो वो दूसरा वाला में आएंगे. B जब होगा,
Agreement to sell is neither a document of title nor a deed of transfer of property.
in the said judgment, it has also been observed that agreement of sale is neither a document of title nor a deed of transfer of property by sale, as the same, and as such it shall not confer absolute title upon the property in view of section 54 of the Transfer of Property Act 1882. Section 54 of the Transfer of Property Act defines sale, and there is a specific provision under section 54 with regard to contract for sale, wherein it has specifically provided that a contract for sale of immovable property is a contract that the sale of such property shall take place on terms settled between the parties, and it does not of itself create any interest in or charge of such property. This court is of the view that Section 53 capital A of Transfer of Property Act gives special benefit to those persons who are in possession of the property by virtue of an agreement of sale and have acted in terms of the said section. But there can be no dispute that the agreement of sale by itself does not confer title. In the present case, the agreement of sale, as discussed above, agreement of sale having been entered after the cutoff date, 2001 वाला date ले लेंगे. Therefore, this court is of the view that the appellants have not acquired title over the property by virtue of part performance of agreement of sale, Exhibit D, and therefore they cannot deny their legal obligation to pay rent to the plaintiff once there is a concurrent finding of landlord-tenant relationship between the parties, which has been returned by both the courts after appreciating the oral and documentary evidences led by both the parties. Consequently, the first substantial question of law is answered against the appellants and in favor of the respondent. So far as the second substantial question of law is concerned, the point is as to whether the suit under JBC Act was itself maintainable when both the parties were claiming title over the property. This court is of the view that so far as the principle of law regarding entry into the dispute of landlord-tenant relationship in a suit for eviction under Rent Control Act is concerned, the learned counsel or the appellant has rightly relied upon the judgment passed by Honorable Patna High Court reported in 1991 SCC Online Patna 140. Wherein, by referring to the judgment of the Honorable Supreme Court in AIR 1988 Supreme Court 1772, where it was held that in a suit instituted by the landlord against his tenant on the basis of contract of tenancy, a question of title could also incidentally be gone into, and that any finding recorded by the small causes court in this behalf would not be res judicata in a suit based on title. And in paragraph 69 of the aforesaid judgment, it has been held that the issue of title can be incidentally gone into in a suit relating to landlord-tenant relationship. In uh, reliance has also been placed in paragraph 63 of the abusive judgment in order to submit that in a case where there is a tenancy and the predecessor in interest sells the property and the tenant continues to be in possession of the premises, the issue for consideration which fell before the court was whether the defendants came in possession of the suit premises upon their induction as tenant by the plaintiff when he purchased the land in question by the reasons of the same deed executed by the original owner or was in possession by reason of the other two deeds of sale from the co-sharer of the property. It was in the facts of that case, the Honorable Court held that the said issue was not at all addressed by the concerned court below. The ratio of the abusive judgment is that once a question of title is raised, the court can certainly incidentally go into the question of title in a proceeding under arising out of landlord-tenant relationship, but the court does not have any jurisdiction to determine the title of one or the other party, and therefore the incident finding of landlord-tenant relationship in such a suit, the incident finding of title in such a suit of landlord-tenant relationship will not operate as res judicata in a properly constituted suit seeking declaration of title. Okay?
I had also read a judgment of Rajan Tiwari.
Yes. In the case of Rajendra Tiwari, reported in bracket 2002 within bracket close 1 SCC 90, it has been held in paragraph 15 of the said judgment that a court of rent controller has limited jurisdiction to try suits on grounds specified in the special act obviously does not have the jurisdiction of the ordinary civil court, and therefore they cannot pass a decree for eviction on the ground other than specified in the act. And it has further been held that being the position, कहाँ लिखा है incidentally can go into the title. Which paragraph is that? In the same case, the High Court had remanded the case to the first appellate court to determine the question of title between the parties in a proceeding under the provisions of the Rent Control Act. Such order was set aside by holding that the rent controller, the suit in connection with landlord-tenant relationship has no jurisdiction to decide the title between the parties. However, when the judgment passed by Honorable Patna High Court and a aforesaid judgment of Honorable Supreme Court are read together, it is apparent that the question of landlord-tenant relationship can be incidentally gone into, and such finding does not operate as res judicata when a regular suit seeking declaration of title is filed. वो जो फर्स्ट क्वेश्चन ऑफ लॉ था ना उसमें एक चीज थोड़ा छूट एक जजमेंट है ना उसमें लिखा द काउंसिल फॉर द रेस्पोंडेंट पिटिशन अपीलेंट हैज रिलाइड अपॉन द जजमेंट reported in bracket 2010 bracket 25 ACC 401 and has referred to paragraph 16 thereof to submit that even unregistered agreement of sale is admissible in evidence. This court is of the view that said, and it can be relied upon for collateral purposes. This court is of the view that said judgment does not apply to the facts and circumstances of this case, as the same was in relation to relief to seeking specific performance of contract. Seeking specific performance of contract based on unregistered agreement of sale in view of specific provision made under section 53 capital A of Transfer of Property Act and corresponding provision made under section 17 within bracket 1A of the Registration Act. This court is of the view that the aforesaid judgment does not apply to the facts and circumstances of this case when it comes to claim of specific part performance of contract and seeking protection of section 53 capital A of Transfer of Property Act. Having held as aforesaid, second substantial question. Having held as aforesaid, this court is of the considered view that there is no absolute bar in maintainability of a suit under BBC Act when both the parties were claiming title over the property. However, the court would incidentally enter into the point of title as and when such claim is made to decide the relationship of landlord and tenant between the parties. As the first substantial question of law has been answered against the appellant, and the appellant has been claiming title over the property by virtue of part performance of unregistered agreement of sale, whereby part payment of the consideration amount was made. Therefore, ये तो सिर्फ मेंटेनिटी पर ही आया है, इसको नहीं करेंगे. In view of the aforesaid findings, this court is of the view that the suit was maintained. Consequently, the second substantial question of law is also answered against the appellant and in favor of the respondent. Both the substantial question of law having been answered against the appellant and in favor of the respondents, there is no merit in this appeal, which is hereby dismissed. बस हो गया. कल का पार्ट डिक्टेशन है, तो कल सैटरडे है, कल हम आएंगे कोर्ट में, तो इसको हम लोग कल करेंगे, हो जाएगा कल तक, है ना.
Item 51, CLP 109 of 2025.
Yes, where is the petitioner?
Item 51.
Nobody appears on behalf of the parties. Pose this case on. Are you there? Petitioner absent. Counsel for the opposite party is present. Post on 2nd of January 2026. Restoration में जो भी absent हो उसका यही order करने का है. 2nd January 26 is the next date in case of restoration where the petitioner is absent. ठीक है ना? कोई हड़बड़ी नहीं है. Dismiss for default करा दिए हैं, restoration में आते नहीं. चलिए कॉल करें.
Item 52, CLP 110 of 2025.
The CMP is filed for restoration of non-compliance with the MP order dated 17/5/2024. Very much the batch notice were taken when there was the MP order to cure the defect, and just after the order was filed, there was a break for summer vacation. What a mistake on the part of the
Back matter मतलब?
kindly see page number 10. Page number 10 of the CMP.
कब का order है ये?
17/5/2024.
इसका तो YouTube पे होगा. देखें एक-एक केस कॉल आउट करके ऑर्डर. तो ये बैच मैटर क्यों बोल रहे हैं?
Batch order in batch.
बैच ऑर्डर.
A batch.
हमारे
order.
स्टेनोग्राफर के पास कोई काम नहीं है क्या? DFD का ऑर्डर ड्रॉ करते
No,
रहेंगे.
no, that is not the ground. The ground is that just after the
इसलिए
order.
बैच मैटर मत.
That is not the ground.
We call out every case
Yes, yes.
individually and then pass the order.
This was a bona fide mistake on our part. That's why the BMP order was not complied with him.
एक केस में इसी सबमिशन पर हम कॉस्ट भी लगाए हैं. आपको मालूम है? कि नहीं मालूम है? CLP number 110 of 2025. Counsel for the parties are present. This petition has been filed for restoration of WPS number 7261 of 2023, which stood dismissed on account of non-compliance of order dated 17/5/2024. Counsel for the petitioner has submitted that due to inadvertence, the defects could not be removed within the stipulated time, and the case has been dismissed. Counsel for the respondents has no objection for prayer for restoration. Considering the submissions, the time granted for removal of defect in WPS number 7261 of 23 by order dated 17/5/2024 is extended till 17th of April 25. If the defects in the aforesaid petition is removed within the extended time, office is directed to place the petition before appropriate bench as per roster. CMP is disposed of.
Item 53, CMP 121 of 2025.
Yes.
Same.
Same order,
Same.
चलिए same prayer, same order, same काम. Inadvertence, क्या लिखे हैं आप? जज पे एलिगेशन नहीं ना लगा दिए हैं कि एक साथ जो है एक केस में ऐसा हुआ था. पिटीशन में लिखे थे कि अचानक जज साहब आइटम नंबर 100 कॉल फॉर कर दिए, तो द केस वाज डिसमिस्ड.
मेरे पार्ट पे गलती है तो कैसे?
चलिए, आपको ऑब्जेक्शन है? सेम ऑर्डर कर देंगे.
एक हद तक पास समय बढ़ा दीजिएगा मैडम, यानी कि हमको
17 अप्रैल तक किया
तो
है.
उसको 21 अप्रैल तक कर दिया जाए.
17 अप्रैल को 24 अप्रैल तक.
24
ठीक है
अब लाइक
सौरभ. अभी पिटीशन का नंबर वगैरह अलग होगा, ऑर्डर का डेट सेम.
Item 54, contempt civil 1/4 of 2025.
Yes.
It hasn't complied yet. The petitioner himself have acknowledged it also in an actual deed.
What was the nature of order?
For encroachment to be removed, illegal encroachment to be removed from the public land.
It has been removed.
Yes, and in an actual deed, it has been mentioned petition that petitioner himself has acknowledged that.
Proceeded with removing the encroachment. कहाँ लिखे encroachment has been removed?
यहाँ एनेक्शन डी पे लिटिगेशन यहाँ लिखा कि अंचल अधिकारी एवं पुलिस बल के प्रस्तुति में मौजूद पांडेपुरा के खाता संख्या 123 एनेक्शन डी ऑफ शो कॉस्ट लिटिगेशन प्लॉट संख्या 690 रकबा 0.004 प्रकार गैर मंजूरिया ग्राम आम किस्म रास्ता के भूमि को अतिक्रमण मुक्त कराया गया. एंड नीचे लिटिगेशन को पिटिशनर का साइन दिया.
देखिए contempt civil 144 of 2025. Learned counsel for the petitioner is absent. Counsel for the state is present. Counsel for the state has referred to the show cause, and in particular page number 30 of the show cause to state that the said document contains a signature of the petitioner and he has endorsed that the encroachment over the road has already been removed, has been removed. She submits that the order passed by this court in
WPC 147319.
WPC 1473 of 2019 has been complied. Considering the show cause, this court is not, and particularly Annexure D, this court is not inclined to proceed any further in this contempt proceedings, which is hereby brought.
Item 55, content civil 147 of 2025.
A decision has been taken and a show cause has been filed. The Lordship may kindly see that as well at page 9.
What was the nature of order?
The order was to consider the condemnation of delay. The application of condemnation of delay is at page 16.
And then pass an order.
Yes, Your Lordship.
So again the delay has been
The delay,
condoned or rejected.
no, the delay has been condoned and the
Case has been decided
and
on
the case has
merits.
been rejected.
Contempt civil आपके फेवर में क्या कि अगेंस्ट
Rejected.
Reject कर दिया। I'm only praying that liberty may be valid not to be.
Contempt civil 147 of 2025. Counsel for the parties are present. The learned counsel for the opposite party has submitted that the show cause has been filed annexing the recent order, thereby the delay in filing the appeal. Appeal था ना?
Yes, Your Lordship.
Appeal has been condoned, but the case has been decided against the petitioner on merits. At this, counsel for the petitioner has submitted that liberty be reserved with the petitioner to take appropriate steps in connection with the reason. Considering the aforesaid facts, this court is not inclined to proceed any further in this contempt proceedings, which is hereby brought. So far as, however, liberty is reserved with the petitioner to take appropriate steps in connection with the recent order as may be permissible under law.
Item 56, content civil 158 of 2025.
Who is there? Yes, madam. Okay. Yes, बताइए कौन है इसमें? We are for the opposite party. Recent order has been passed. Recent order has been passed.
Leadership, I'm not aware, I'm chief with leadership 6 weeks and for the final counter.
6 weeks.
Show cause.
6 महीना क्यों नहीं? Why not 6 months or maybe 6 years? Time has already expired. आपको कब सर्व हुआ है? 22/8/2024. It has been served on you. For what purpose?
Leadership.
बताइए. क्या हुआ? Order comply हो गया?
Not complied with leadership.
कौन compliance report फाइल करना है? क्या करना है? Order को challenge किए हैं? LPA किए हैं?
Your leadership, my prayer was for promotion after completion of 20 years and 30 years of service of the petitioners.
What is the age of the petitioner? How many? What is the age of the petitioners? सब senior citizen हो गए हैं. देखिए here. Contempt Civil 158 of 2025. This petition has been filed alleging non-compliance of order dated 18/3/2024, passed in WPS number 2381 of 2023, after serving copy upon the state on 22/8/2024. Today, when the case is taken up, the learned counsel for the opposite party seeks time to file a compliance report. Post on 30th April in the supplementary cause list, the compliance report should be filed by 28th of April.
Item 57, Contempt Civil 168 of 2025.
I see order has been complied.
Contempt Civil 168 of 2025, the learned counsel for the parties are present. The counsel for the petitioner has submitted that. Order passed by this court in WPS number 613 of 23 dated 3/4/2024 has been complied.
This will get a complete title benefit करना है। सेकंड वाइफ के तरफ से हमें तो मेरे बच्चे का भी साइज में मिला है। तीन बराबर।
आपको कोई ग्रीवांस बाकी है?
कोई ग्रीवांस नहीं, खाली पेमेंट का
पेमेंट की?
पेमेंट खाली बस देख लीजिए।
ऑर्डर देख लीजिए। एज पर कि मुझे तीनों को पेमेंट अब मिलेगा, क्योंकि ये सेकंड वाइफ की
मिलेगा ना?
हाँ मिलेगा, वो जो ऑर्डर लगाए हमने पेज नंबर।
ऑर्डर तो लगाया है, पेमेंट कहाँ है?
जो डिसीजन, वो जो ऑर्डर था डिसीजन लेने के लिए।
अच्छा।
दो वाइफ आई हुई थी तो था कि
डिसीजन लेने के बाद पेमेंट करने का ऑर्डर नहीं था, उसके लिए अलग से ऑर्डर।
नहीं, वो जो पेमेंट एज पर स्कीम सब पे जाए, सबके पास जाएगा।
Counsel for the petition has submitted that the payment arising out of the reasoned order has not been made. Counsel for the opposite party submits that he shall make all endeavor to ensure that payment is also remitted in terms of the reasoned order. Considering the aforesaid submissions, this court is not inclined to proceed any further in this case. And the present contempt proceedings are hereby dropped. The counsel for the opposite party is directed to communicate this order to the opposite party number 2 to abide by the undertaking given by the counsel during the both proceedings.
Item 58, Contempt Civil 171 of 2025.
Yes, ma'am.
Yes, last week notices were issued to the OP number 2 and there was direction to file the compliance report. The pension of to the hospital of the petition was supposed to be.
Notice has been served.
Yes, Your Honor.
Anybody appearing? Who is OP number 2?
OP number 2 is the executive officer or administrator of Pakri Nagar Parishad.
Is there a standing counsel?
Name of Suresh Kumar Advocate.
Is there? Has somebody has entered appearance? they were supposed to pass a reasoned order.
Yes, after considering the demands of the petition. And show one at page 8 is the operative portion, paragraph 6.
तो इनके ऊपर कंटेंट प्रोसीडिंग शुरू करना पड़ेगा। बताइए कैसे शुरू करें? बताइए। बढ़ क्या है कंटेंट प्रोसीडिंग कैसे शुरू करें?
Contempt of courts act.
हाँ तो बताइए व्हाट इज द प्रोसीजर?
Notices may be issued that charge will be framed against them if they always not comply with.
कंटेंट केस सिविल पढ़ के आइएगा अगली बार, ठीक है? कंटेंट केस सिविल नंबर 171 of 2025. The notice was issued to the opposite party number 2 on 14/2/2025 on the submission of the counsel for the petitioner that order passed by this court in WPS number 7619 of 2023 dated 22/2024 has not been complied. The notice has been served, but neither anybody has entered appearance nor anybody is appearing on behalf of opposite party number 2. This court is prima facie satisfied that the opposite party number 2 is on the perusal of materials on record has no regards to the orders passed by this court. Neither any compliance report has been filed, and nor he has entered appearance before this court in spite of service of notice. The office is directed to issue fresh notice to opposite party number 2 as to why a contempt proceedings be not initiated against him for willful and deliberate non-compliance of order passed by this court through the concerned police station. State है इसमें?
Yes, Your Lordship.
The counsel for the state is directed to seek instructions from the concerned police station and file service of notice. The service of notice should clearly indicate, the service of notice should be made in presence of 2 witnesses, and Aadhaar card of the 2 witnesses and the opposite party number 2 should also be annexed along with the service report. Since nobody is appearing on behalf of the state, let a copy of this order be communicated to the Office of Learned Advocate General for compliance. Post this case on second of May in the supplementary cost list. उस दिन सोच के आइएगा, जब तक तो appear अगर नहीं होंगे तो the affidavit of service should be filed by 28th of April. एक केस में किए हैं, ड्रॉ किए हैं, खोजिएगा मिल जाएगा। क्या नाम था? आज केस उसका कंटेंट लिस्ट में था, उसी में ड्रॉ किए। क्या नाम था उसका इसमें? बादल। इसे पता नहीं चलता।
Sorry, not 58 but sometime.
क्या चीज़? इतना देर हम ऑर्डर लिखा दिए।
Good, we'll comply with that. We will comply with that.
Who will comply with order? आराम से बैठ जाइए
एग्जीक्यूटिव ऑफिसर नगर परिषद
क्यों नहीं किए हैं कंप्लाइन? वकालतनामा भी नहीं फाइल किए हैं
एक्चुअली उन लोगों का सीक्रेट कोई वकील है नहीं
तो करेंगे ना वकील अपने खर्चे पर।
they have said
आपको
actually-
वकालतनामा नहीं है ना? आपको वकालतनामा है?
नहीं वकालत
तो बस चलिए सेम
एक्चुअली
क्या होगा? कुछ नहीं किए हैं, हम नोटिस किए हैं, जाएगा पुलिस स्टेशन से, आप अपना कंप्लेंट वो फाइल करिए। ऑर्डर होने के बाद प्लीज डोंट से।
हमारे पर्सनल एक्चुअली वो लोग भेज चुका है हमको और उनका रिक्वेस्ट किया है दूसरे कोर्ट में फंस गए थे वेरी सॉरी 1 सप्ताह का समय इसमें दे दीजिए 2 सप्ताह का समय दीजिए आई एम नॉट सेइंग अबाउट वेरी लॉन्ग टाइम 2 वीक्स लास्ट वीक में आगे वाला वीक में जो थोड़ा सा छुट्टी ज्यादा है तो 2 सप्ताह का समय
आपके ऑफिसर छुट्टी पर हैं?
नहीं छुट्टी पर नहीं है
वो तो नहीं छुट्टी पर है। कंप्लायंस रिपोर्ट कब फाइल करिएगा? फ्राइडे तक फाइल करिए। उनको बोलिए काम करने, आप रहिए
फ्राइडे
आप छुट्टी पे रहिए, उनको बोलिए काम करने।
नहीं हम छुट्टी पर नहीं हम अपनी छुट्टी पर नहीं मतलब दे विल फाइल द कंप्लायंस ऑर्डर दैट्स व्हाई
देखिए ऑर्डर हम ऑलरेडी दिखा चुके हैं। अब इस ऑर्डर को हम तभी रिकॉल करेंगे जब आप अगले फ्राइडे तक कंप्लायंस रिपोर्ट फाइल करेंगे। अच्छा लिखिए एक सेंटेंस और। आफ्टर द डिक्टेशन ऑफ द ऑर्डर पास बाय दिस कोर्ट मिस्टर सुरेश कुमार छोड़िए इतना क्या लिखा है। चलिए फिर से टेक इट अगेन। Counsel for the petitioner submits that the order passed by this court has not been complied. Mr. Suresh Kumar appears and submits that he has received instructions from opposite party number 2 and has prayed for some time to file a compliance report. He has further submitted that the matter is under active consideration of opposite party. Post on 16th April.
Yes.
In the supplementary cause list.
Yes.
The compliance report should be filed latest by 11th of April.
Yes.
Item 47, but the order has been complied, the regional order has been passed, this so-called
कौन सा 47 में क्या किया?
47, regional order had to be passed.
Follow up हो गया?
No, I could not.
2-5 के लिए
Order has been passed. Order has
इसमें
been
2-5 के लिए पोस्ट कर दिए हैं। आप 2-4 जूनियर रखिए मिस्टर सिंह, आप हमेशा एब्सेंट रहते हैं कोर्ट में। नहीं आप 2-4 जूनियर रखिए, बढ़िया जूनियर। अच्छा से पेमेंट करेंगे तो आपको बढ़िया पेमेंट मिलेगा।
Regional order has been passed, I filed a so-called
वो ऐसे नहीं ड्रॉप हो सकता है।
हम आएंगे।
जिस दिन नेक्स्ट डे होगा उस दिन आ जाइएगा, लेकिन आपके केसेस में आप हमेशा नॉन अपीयरेंस रहता है, थोड़ा इसको ध्यान रखिए, है ना? 10:30 बजे तो अगर कोई केस कॉल आउट हो जाए तो हमको नहीं ध्यान है कि आप कभी किसी केस में आएंगे।
Item 59 CMP 189 of 2025.
Lord, in this matter, petitioner paid for explanation of WPS number 3563-23, my lord. Lord, in this matter, my lord, due to the bona fide mistake of the advocate, my lord, the surviving defect has not been removed within time, my
देखिए
lord.
CMP number 189 of 2025, counsel for the parties are present. Counsel for the petitioner, this petition has been filed for restoration of WPS number 3563 of 2023, which stood dismissed on account of non-removal of defects in terms of preemptory order dated 17/2/2024. The learned counsel for the petitioner has submitted that on account of inadvertence and bona fide mistake, the defects could not be removed. Counsel for the opposite party has no serious objection to the prayer for restoration. Considering the opposite submissions and being satisfied with the cause shown, the time for removal of defect in WPS numbers 3563 of 2023 is extended till 17th of April 2025. If the defects are removed in the posted petition, office is directed within the extended time. Office is directed to place the petition before appropriate bench as per poster. The CMP is accordingly disposed.
Item 60 CMP 201 of 2025.
is it?
Restoration.
आप restoration में किस लिए आए हैं?
Why not comply? My friends would have been here. Miss. He
हाँ,
said
आप
that.
क्यों आए हैं? आप आए हैं इसलिए नहीं करेंगे।
तो कभी
आप
कभी तो मौका
restoration
लगा,
में क्यों
आपका
आए?
रोस्टर के हिसाब से हमारा कोई काम नहीं रहता, हिसाब कर दिए हम लोग, क्या करें?
हम क्या किए?
तो कभी कभी हमको आना वही है, फॉर नॉन कंप्लायंस ऑफ क्वालिटी।
हमारा रोस्टर एलीट क्लास के लिए है। एकदम जो आराम से अपना केस करते हैं, फर्स्ट अपील, सेकेंड अपील, सिविल लॉ एकदम एलीट क्लास का केस है।
तो उसमें हमारा काम ही नहीं रहता एलीट में।
We have only handful of advocates in civil law. ये क्या करना है? देखिए, CMP number 201 of 2025. So for the parties are present. This petition has been filed for restoration of WPS number 1308 of 2018, which has been dismissed on account of non-compliance of order dated 6/4/2024, as the defects could not be removed within stipulated time. The learned counsel for the petitioner has submitted that on account of inadvertence,
Yes.
inadvertence, the defects could not be removed. And he prays that the writ petition be restored. The learned counsel for the opposite party has no objection to the prayer for restoration, considering the submissions and being satisfied with the cause shown. The order for removal of defects passed in WPS number 1308 of 2018 is extended till 17th of April 2025. If the defects in the petition is removed within the extended time, the office is directed to place the petition before appropriate bench as per roster. This CMP is accordingly distributed. अब आप सुनिए एक बात, हमको पता है अजब क्यों, पता है ना? आप अपने जूनियर को बोलिए कि डांट से ना डरा करें, डर के आगे जीत है, और जो डर गया इस प्रोफेशन में मर गया। डायलॉग सुने हैं ना? इसीलिए आपको नहीं आना था। ठीक, हमको याद रहता है, बहुत चीज हमको याद रहता है। कोर्ट के बाहर सब भूल जाते हैं, कोर्ट के अंदर हमको बहुत चीजें याद रहती हैं। क्या हो गया, किसी दिन कोर्ट से डांट पड़ ही गया तो क्या?
हाँ होता है उसमें।
और कभी गलती किए तो डांट नहीं भी तो पड़ा था,
हाँ।
तो वो उसी का खामियाजा है।
और सब कोई फेस किया हुआ इस चीज को, इतना परेशान होने का
परेशान होने की कोई बात नहीं। चलिए,
Item 61 CRNT 213 of 2025.
We have filed an modification of the order as per your last. We have asked us to file the modification. We have filed it. Both the cases may be tagged together. This case.
modification.
This was the release of money. The last occasion we have the petition may recall. There was a discussion to file the modification for the order of
Revision.
the coordinate bench. So we have filed the CRMP for modification of that particular order.
What modification are you seeking?
We should in that order the whole sentence and the judgment has been set aside, due to which the issue arose payment should not be made in favor of this petition.
Will issue notice.
In this
बिना notice के।
and that modification CRMP may be tagged.
ये क्या फाइल किए हैं?
This was for the release of money.
Modification petition कहाँ है?
We have filed it that is CRMP number 821 of 2025.
तो वो तो आया ही नहीं है ना अभी. I'm simply adjourning it. आप उसको mention करके साथ में लगा. CRMP number 213 of 2025. At the request of the council for the petitioner, the matter is directed to be posted on 11th of April. Slip दीजिए, साथ में tag कराइए same date के लिए. तब वो दिन लग जाएगा उसको. ठीक है? And then
Item 62, contempt civil 270 of 2025.
yes, order has been complied.
Where in this case, a regional order has been passed, and I believe its copy has been given to the petitioner. And copy has been given to the petitioner.
Recent order has been passed.
Yes, yes.
Contempt civil 270 of 2025. Counsel for the parties are present. The counsel for the parties have jointly submitted that a recent order has been passed pursuant to order dated 30/4/2024 passed in WPS number 2710 of 2023. And accordingly, the order passed by this court has been complied, though belated. Considering the submissions, this court is not inclined to proceed any further in this continuing proceedings because hereby stopped.
Or like-
Liberty to challenge.
वो हम अपने मन से क्यों लिखे? आपका कौन सबमिशन करेगा? आपका सबमिशन हम तो भी करेंगे. At this, the learned counsel for the petitioner, however, the counsel for the petitioner has submitted that liberty which is reserved with the petitioner to take steps in connection with the reasoned order. Liberty is reserved with the petitioner to take steps in connection with the reasoned order as may be permissible under law.
Like,
Item 63, CMP 277 of 2025.
compliance the order written. So, balance and the choice.
डिफेक्ट नहीं रिमूव किए थे. CAP number 277 of 2025. Counsel for the petitioner is present. Nobody appears on behalf of the opposite side. Counsel for the petitioner submits that this petition has been filed for restoration of WTC number 6069 of 2022, which stood dismissed for non-removal of defects in terms of order dated 11/6/2022. Counsel for the petitioner has submitted that on account of the fact that father of the counsel for the petitioner was ill, he was out of station, and therefore the defects could not be removed within the stipulated time. Considering the aforesaid submissions and being satisfied with the clause shown, the time for removal of defect in WPC number 6069 of 2022 is extended till 17th of April. If the defects in the petition 24th of April 2022. If the defects in the petition is removed within the extended time, the office is directed to place WPC number 6069 of 2022 before appropriate bench as per roster. This CMP is accordingly disposed of.
Item 64, CMP 278 of 2025.
आपका भी केस डिस्कस हुआ? कितने अलर्ट रहते हैं? बेंच नहीं पसंद आ रहा है.
No. But I have given my statement when the case was listed. I was suffering from fever. That's why.
Counsel for the petition is present. Nobody appears on behalf of the state. इसका number है CNP number 278 of 25. This petition has been filed for restoration of WPS number 7467 of 2023, which stood dismissed on account of non-removal of defects. Defect ही था ना?
हाँ.
Pursuant to order dated 17/5/2023. The counsel for the petitioner has submitted that since he was ill, he could not take steps for removal of defects within the stipulated time. Considering the aforesaid submissions and being satisfied with the cause shown, the time for removal of defect in the WPS number 7467 of 2023 is extended till 17th of April 25. If the defects are removed within the extended time, the writ petition is directed to be listed before appropriate bench as per roster. The CLP is accordingly disposed of.
Shiva, CL 63 में
63 कौन सा?
वही restoration not been
कोई बात क्या होगा?
नहीं
No
बस
loss.
still if possible.
Item 65 CNP 279 of 2025.
For restoration of the petition, which was got dismissed due to non-compliance of order for removal of the defects. Few pages were missing. Type copy of few pages were missing. Type copy were filed.
The learned counsel for the parties are present. This petition has been filed for restoration of WPS number 1859 of 2020, which stood dismissed on account of non-removal of defects in terms of order dated 30/3/2020. The learned counsel for the petitioner has submitted that on account of inadvertence, the defects could not be removed. The learned counsel for the state has no objection to the prayer for restoration. Having gone through considering the submissions and being satisfied with the cause shown, the time for removal of defects in WPS number 1859 of 2022 is extended till 17th of April. If the defects are removed within the extended time, office is directed to place the petition before appropriate bench as per roster. This CLP is accordingly disposed of.
Item 66 CRMP 289 of 2025.
This CRMP note has been filed for restoration of criminal revision number 1461 of 2020.
क्या डिफेक्ट? क्या डिफेक्ट? सरेंडर सर्टिफिकेट अगर था तो लेकर आए, नहीं तो हम नहीं करेंगे.
Other side, my lord, is appearing, the complainant is appearing in this case, and lord, there is a compromise.
We will not bother about it. बिना डिफेक्ट रिमूव हुए रिवीजन हम रिस्टोर नहीं करेंगे. अभी एक मिस्टर साहनी का रिलीज.
But in that scenario, we not let this case not be yet 2 weeks. By that time.
CRMP number 2704 of 25. At the request of the counsel for the petitioner, the matter is adjourned and is directed to be posted on 2nd of May.
Item 67 contempt level 316 of 2025.
This complaint was regarding payment of 7th pay revision in pension, Already order was passed by your lordship and 6 months time was already given at the time of writ disposal. But till date, Ranchi University has received entire money and state government has filed a counter show. He has said that 700 crore has been given in this fund for payment of pension. But Ranchi University is keeping mum over the matter, not giving a single penny. And 1/4 pension is being paid. As per the 4th pay revision the petition is being paid. Now the seventh revision order has been given by the University. Ranchi University normally does not give reply until 2-3 times below the show the issue. So let the registrar appear.
आज तो आए थे रजिस्टर रांची यूनिवर्सिटी कौन आए थे ना तो ये रिकॉर्ड नहीं दिखाए उनको
Your edition, this case is coming up for the first time.
So-
And as per my instruction, we are yet to receive any instruction from the college. A demand has to come from the college that
College has not
Demand
submitted.
has already
has
been
not been
given.
raised.
Demand
Karim City College, Jamshedpur, from where the petitioner retired Melody, it has been given around 6 months back. Demand has been given.
6 महीना पहले आए थे first time.
Let the Ranchi University pay within 2 weeks. Your worship pass this order, then immediately they will come with the check.
Your leadership, Karim City College is also a party.
6 months time was given to the Ranchi University earlier, and it was not paid. Earlier, the
Karim City Colleges respond opposite party number 4. Contempt civil 316 of 2020. Counsel for the parties are present. Counsel for the petitioner has submitted that this petition has been filed alleging non-compliance of willful and deliberate non-compliance of order dated 15/5/2024 passed in WPS number 424 of 2020. Yes, submitted that as per the show cause filed by opposite party number 2, the entire payment amount has been remitted to the university, but the petitioner has not received a penny in terms of the order passed by the school, and the petitioner is receiving only a meager amount of pension. The Council for the university has submitted that the required details and demand for payment from the concerned college, namely Karim City College, Jharkhand, has not been received by the university, and the moment the demand is received, the amount will be remitted. Let notice be issued to opposite party number 2. Opposite party number 4, the principal of Karim City College and Jharkhand, through the concerned police station, for which requisite be filed by the petitioner within a period of by Monday 5 Counsel for the state of state is directed to seek instructions from the concerned police station and file affidavit of service. ठीक है कर देंगे?
The state government has filed affidavit. They have said in para 6 that 700 crore has been sent to Ranchi University. University is not paying. Para 6, it has been stated.
Post this case on 2nd of May. The affidavit of service, the service of notice be filed by 29th of April. 28th of April, 28 April तक फाइल कर दीजिए.
Item 68, contempt civil 323 of 2025.
The order has not been complied. They should kindly granted to file a compliance report. Price representation has been delayed. The direction to pass a reason order at the same time.
Reason order in need, evidence का भी order.
Kindly granted to file a compliance report at the same time.
Counsel for the parties are present. The counsel for the opposite party number 2. The counsel for the state. Submits that he shall seek instructions from opposite party number 2 and file a compliance report. It is relevant to note that as per the order passed by this court, if the petitioner is found entitled to any monetary benefit arising out of the recent order, the same is also required to be remitted to the petitioner. The compliance report should not only enclose a copy of the recent order, but also indicate the manner in which the admissible amount has been remitted to the petitioner. पैसा दे के आइए, ठीक? Post this case on 2nd of May. The compliance report should be filed by 28th of April. Second, रीजन ऑर्डर अगर करना है, इनको सुनने उनने का कोई डायरेक्शन होगा तो इनको बुला के सुन के ऑर्डर करेंगे, ऐसे ही एस्टिमेट करके.
Item 71 contains Bill 402 of 2025.
My lord, order has not been complete.
देखिए, content case civil number 402 of 2025. Counsel for the petitioner is present. Nobody appears on behalf of the opposite parties. This petition has been filed alleging deliberate and willful non-compliance of order dated 15/3/2023 passed in WPC number 5584 of 2012. Let notice be issued to the opposite party number 2 for which requisites as to why a contempt proceedings be not initiated. The requisite be filed by the petitioner within a period of 1 week from today under ordinary process. Post this case on 8th of May in the supplementary cause list, awaiting service of notice and also filing of compliance report.
Item 72 contains Civil 438 of 2025.
Are you there for the respondent?
Yes,
Why are you?
I'm seeing.
You have filed as LPA?
This can't be the first time.
You have filed LPA?
We are not aware of the issue. As far
You are
as
not
the-
aware? What are you representing and whom are you representing?
We represent same in this matter. Similar relation in this, there was a specific direction wherein we were told to provide a breakup of the calculation, which we had provided. But he has raised objections. To the objections raised by him, whether we have replied or not, we do not know. I've written a mail, your lordship, I'm praying for 3 weeks time to
Contempt Civil 438 of 2025. Counsel for the parties are present. Counsel for the opposite party praised for and is granted time till 2nd of May to file a compliance report. Post this case on 8th of May in the supplementary list. The compliance report, कब तक दिए आपको time? 2nd of May. You should file it by then.
Item 73 CRNP 512 of 2025.
For modification of order dated 18
What modification? क्या modification है?
पैसा जमा करना था उस डेट में अपोजिट पार्टी को फाइल किया
क्या चीज का पैसा जमा बताइए। 21 तारीख को आप एपीआर नहीं हुए थे?
एपीआर हम हुए थे, अपोजिट पार्टी नहीं।
कहाँ लिखे?
ये क्या लड़ से पैराग्राफ 9
ऑपोजिट पार्टी नहीं एपीआर हुआ था, आपको कोर्ट में जमा करना था ना पैसा।
बैंक डिटेल लेवल देखा है।
पैरा नंबर 9 यहाँ जमा कर दीजिए, हाईकोर्ट में जमा कर दीजिए। 4 weeks you are ready with the money, you deposit.
2 times
Judges
2 times
2 times दो पार्ट में क्यों करेंगे? आप तो गए थे उस दिन पैसा लेकर, जमा कर दीजिए।
बैंक डिटेल में जाए
बैंक डिटेल हम दे रहे हैं, हाईकोर्ट का बैंक डिटेल। तो अब ऑपोजिट पार्टी को नोटिस करेंगे, उसको यहीं से पेमेंट करेंगे।
ठीक है। 2 सप्ताह का 2 सप्ताह का टाइम चाहिए।
ऐसा होता है कि जिसको पैसा लेना है वो नहीं आ रहा है।
नहीं आता।
अच्छा,
अगर आप
वकील साहब को तो नहीं ही देना था, अपने हाईकोर्ट का में जमा करा दीजिए, ठीक है?
2 weeks टाइम
ठीक। CLMP number 512 of 2020. The learned counsel for the petitioner has submitted that this petition has been filed for modification of order dated 18/9/2024 passed in criminal division number 1534 of 2019, wherein the opposite party number 2 was directed to provide bank account details to opposite party. Bank account details of the opposite party number 2, so that the petitioner will be able to deposit the compensation amount of rupees 5,50,000. Sorry? अब तो आप RTGS कर दीजिए हाईकोर्ट में, हम लोग दे देंगे उसको। The counsel for the petitioner has submitted that आप एपीआर हुए थे, कहाँ लिखे हैं आप? 21/10 को आप कहाँ लिखे हैं कि आप एपीआर हुए थे 21/10 को? कहाँ लिखे हैं? The council submits that on 21/10/2024, as fixed by this court for appearance before the concerned court, the opposite party number 2 had not appeared. He has also referred to paragraph 12 that the petitioner is very much interested to comply the order of this court, but it was not possible for the petitioner to pay cash of rupees 5,50,000 to the advocate of the opposite party. Considering the aforesaid submissions and the amendments made in the main petition, and the willingness expressed by the petitioner that he is ready to pay, and he's interested to pay rupees 5,50,000 as compensation to opposite party number 2. The petitioner is directed to deposit the aforesaid amount before this court. आरजी का नंबर दे देंगे, पूरा डिटेल, आरजी का सारा डिटेल दे देंगे, and file an affidavit regarding proof of such deposit. The affidavit regarding deposit be filed by 11th of April. ठीक है? The question of issuing notice to opposite party number 2 will arise once the petitioner deposits the amount before this court. पहले जमा करिए फिर notice करेंगे. Post on 16th April in the supplementary list. RTGS कर देंगे, RTGS कर देंगे, उसका प्रूफ लगा देंगे, रजिस्ट्री से कंफर्म कर देंगे, उसके बाद नोटिस कर देंगे.
आइटम
ओपी नंबर 2 कहाँ रहते हैं? मोराबादी ना, तो यहीं से नोटिस करेंगे. फोन नंबर है उनका? वो आपको पैसा देना है उनको, आपके पास ना फोन नंबर है, आपको देना है तो वो काहे के लिए आप उनका नंबर है?
Item 74 CRAP 562 of 2025.
CRMP has been filed for distribution of criminal division 572.
What was the defect?
For the division, the defect was pertaining to filing of surrender certificate.
You surrender?
It was the burden to file a joint compromise eviction. That's all.
नहीं चलेगा.
3 weeks time.
CRMP number 562 of 2025. Counsel for the petitioner, prays for time. Post on 25th of April.
Item 75 CRMP 621 of 2025.
For restoration of criminal region number 40 of 2020.
क्या defect?
Surrender certificate regarding.
फाइल कर दी?
Lordship, once that Annexure 3 may be seen, Lordship. Page 12. Parent 2, Lordship. Earlier it was dismissed for default for non-compliance of the order, Lordship. Surrender certificate नहीं submit कर सके थे earlier. तो फिर वो हम CRMP फाइल किए तो उसमें सारा लगा के and prior to this, Lordship, he has already been completed the sentence and released from the jail. That has been considered and again the revision has been restored, but the office has not pointed out that order and again it has
Custody
been
report लेके आइए.
हाँ लगाए कुछ भी लगाए.
कहाँ है custody?
Annexure 2 देखा है. उसी को कंसीडर उसी आरएमपी में लगाए थे पहले. एक बार अर्लियर ये डीएफडी हुआ था.
Annexure 2 is page number?
Page 10. Page 10. ये उस सीआरएमपी में भी लगाए. उसी को कंसीडर करके रिस्टोर हुआ.
On the strength of पढ़िए, on the strength of permanent warrant पढ़िए.
On the strength of permanent warrant issued against the convicted accused, namely Dilip Kumar, son of so and so, Hidariba, Badabajar, Rajdu, arrested the accused and produced him in the court today with forwarding both arrest memo as medical fitness certificates. The accused has not complained any misbehavior of police. The family member of are fully aware about his arrest. Perusal of the case report. From perusal, it transpires that the accused
Release कब हुआ?
release हुए after completing the sentence.
कितना sentence?
हाँ ये 3 months का था. हम पैरा लिखते हैं 6 months. 24/1/2020 को गए हैं और 23/4/2020 को रिलीज हो गए. लेकिन ये
ऑफिस का मिस्टेक था लेडीज कि वो डिफेक्ट तो ऑलरेडी हो गया था सरेंडर देने का भी, बट वो पॉइंट ऑफ नहीं किया गया जिसके कारण फिर से ये ले और एक बार जो रिस्टोरेशन हुआ
सरेंडर सर्टिफिकेट आप 3/1/2024 को क्या फाइल किए?
तीन
You say para 6 में that you had obtained the copy of surrender certificate.
हाँ यस फ्रॉम द सर्टिफाइड कॉपी जो निकाले वो 3/1/24 का सर्टिफाइड कॉपी निकाले जब
देखिए CRMP number 621 of 2025. The learned counsel for the petitioner has submitted that the criminal revision number 402 of 2020 was dismissed primarily on ground of non-filing of surrender certificate. He has submitted that the petitioner had surrendered before the court in connection with complaint case number 1259 of 2015.
yes
19
yes
on 24/1/2020 and had served the sentence. He also submits that the sentence was only for 3 months. The learned counsel for the opposite party state is directed to seek instructions and file an affidavit as to whether the petitioner has served the sentence in connection with.
Not let's say after considering the fact annexure 3 जो लगा है
कोई
वो
बात
इसी ऑनरेबल कोऑर्डिनेट बेंच का ऑर्डर है पैरा 2 में लिखा हुआ ऑर्डर दैट इज उसमें
तो सबमिशन लिखना है आप कस्टडी रिपोर्ट फाइल करेंगे क्या पता एक आदमी 3 केस में कस्टडी में जाता है कि कौन सा केस में कब रिलीज हुआ नहीं हुआ इसका डॉक्यूमेंट को सर्टिफाइड कॉपी भी नहीं लगा हुआ है इसमें
पैरा 3 में कंसीडरिंग द रीजन असाइंड इन द प्रेजेंट क्रिमिनल
कस्टडी रिपोर्ट फाइल करेंगे इन कनेक्शन विद दिस केस
कंप्लेंट केस नंबर रिवीजन में
हां
कंप्लेंट केस नंबर रिवीजन पिटीशन में वो साथ में
दे दीजिए डिटेल लिख देंगे ऑर्डर इन कनेक्शन विद कंप्लेंट केस नंबर आप डिटेल दे दीजिए ये जो डिवीजन है ना इसी में जो कंप्लेंट केस का नंबर होगा
कंप्लेंट केस नंबर 1259 ऑफ 2017
द एफिडेविट ऑफ द स्टेट शुड बी फाइल्ड बाय 17th April हो जाएगा
हाँ
3-4 सप्ताह आपको कस्टडी रिपोर्ट फाइल करनी है खुद जाना है क्या
मंगवाना पड़ेगा
हाँ तो मंगवाइए post on 30th April, not 30th, 23rd April in the supplementary cost list.
Okay.
फाइनल रिजोल्यूशन शुरू करते हैं खत्म हो गया
Orders खत्म हो गए?
कंटेम्प्ट शुरू
Orders और कुछ नहीं.
ऑर्डर्स का 4 केस है
तो पहले orders कॉल करिए हम लोग का 4 बजे शेड्यूल है orders कॉल करना.
नोटिस में
आज नोटिस में नहीं चलिए ठीक है फिर आप अपना सेकंड अपील कॉल कर लीजिए जिसमें
Item 5, second appeal 380 of 2017.
Shishma has mentioned this case in the morning. I'm paying for this case on 3rd April.
3rd April को नहीं 3rd April को मैं दूसरे केस रखेंगे.
इसको साइड से
Your file is synopsis of article. Like, और आपका कहाँ है? फाइल कहाँ है इनका? फाइल क्या? देखिए इनका फाइल क्या? पुराना नहीं मिला यहाँ. उसके बाद हम नहीं लेंगे. ये तो पुराना है, ये तो उस दिन मेरे पास था। दिखाइए कहाँ? Where is it? बुला के लेके आइए, पूछिए, क्योंकि पिछली बार ऑर्डर था सिनॉप्सिस ऑफ आर्गुमेंट फाइल करने का, कहाँ है? फाइल की है फ्रेश।
कल ये तो रिस्पोंडेंट का है।
ये तो रेस्पोंडेंट का है,
स्टेट
पिटिशनर का, अपीलेंट का।
Appellant has also filed.
3 to 7. Second appeal number 380 of 2017. The learned counsel for the appellant seeks adjournment. इसमें 3 written submissions हैं। किस दिन रखने बताइए?
No, on third, fourth is the Friday. Third. CMP matters.
थर्ड को हम लोग कुछ रखे हुए हैं और थर्ड we have kept certain matters. फर्स्ट अपील का बैच है उस दिन।
टाइटल मैटर वगैरह प्रॉब्लम टाइटल आ जाता है।
ये आप लोग एक काम करिए कि जितना भी रिटन सबमिशंस आप लोग फाइल किए हैं सबकी सॉफ्ट कॉपी हमें प्रोवाइड करें। मेरा स्टेनोग्राफर क्यों अपना टाइम जायज करेगा टाइप करने में।
ठीक है।
आप प्रोवाइड
हम
करें, उसमें तो कोई दिक्कत नहीं है।
I have perhaps my junior has provided because the
कोई आया
postmaster
है
had said to him to supply the soft copy.
आप ही प्रोवाइड कर दीजिए, ठीक है? क्योंकि अननेसेसरी कुछ एरर हो जाता है, कुछ हो जाता है, फिर इतना टाइप करने में लोगों को टाइम लगता है।
एक मिस्टेक मेरे भी रिटन सबमिशन में हो गया है, उसको हम करेक्शन कर देंगे। तो 2010 सुप्रीम कोर्ट AIR लिखे हैं लेकिन जो कॉपी लगा है वो SCC का लगा दिया।
अच्छा,
लाइक जजमेंट इज द सेम।
वो तो हम लोग उतना कर लेते हैं। थोड़ा सा आप लोग एक बार
सॉफ्ट कॉपी भेज दें, हम जस्ट आई विल।
ठीक है। This matter has been substantially heard on the last date. However, in view of the prayer made by the counsel for the appellant, it is adjourned and is directed to be posted on फाइनल डिस्पोजल में है 7th April। आप उनको सॉफ्ट कॉपी जो है ना मंडे तक, मतलब 2 तारीख तक प्रोवाइड कर देंगे। इसको एक साथ सब टैग कर दीजिए और इसको अलग फोल्डर में रखिए, भूलना नहीं चाहिए हमारे रिकॉर्ड्स।
Item 6, FA 181 of 2023.
This has been issued.
क्या है तो अपील नहीं हुए हैं कोई?
Earlier 2 times, no one has appeared on the behalf of the appellant. The last day also, issue notice to police stations.
Service report has not been received. देखिए FA number 181 of 2023. आप किनकी तरफ से हैं?
Respondent की तरफ से. There is only one independent.
तो आप you will accept notice?
Appellant is not a case in this case.
Oh, appellant is not a case.
Not.
क्यों?
Interested, he is not interested. Earlier,
Yes.
last 3 occasions he has not appeared. Only he has filed application.
On account of non-appearance of the applicants, the notice was issued to them through the concerned police station, but service report has not been received. The state of Jharkhand, through the officer in charge of the concerned police station, that is PO Karma, PS Ramgarh, डिस्ट्रिक्ट हजारीबाग नहीं ये तो नहीं ये तो आप हैं उसमें रामगढ़ है ना PO PS and district Ramgarh is directed to be made as respondent in this case only for the purposes of filing service report with regard to service of notice upon the plaintiff which was issued in terms of order dated 28th of February 2025. Counsel for the opposite party, counsel for the आप कर देंगे insertion कर देंगे cost item में कर देंगे उनको state of अच्छा counsel for the office is directed to make necessary insertion in the cost item of this case. स्टेट की तरफ से कोई है काउंसिल यहाँ पर? Let a copy of this order be forwarded to the office of Learned Advocate General so that a council be appointed for the state to file service report. In terms of order dated 28th of February 2025. This case on 8th of May. The affidavit of the concerned police station should be filed by 5th of May. 8th of May in supplementary process. That's all.
One clear revision. Serial number 54, control has been dropped because the order is incomplete. I was in standing 55 हुआ तो
तो क्या होगा इसका?
मैंने नाम क्लियर किया The Sri Kumar Singh is in the case. He is not well today. He instructed me, but I was sincere apology.
अपना appearance कौन सा serial number?
54.
ड्रॉपिंग में तो कोई प्रॉब्लम नहीं है कंटेंट ड्रॉपिंग में तो
नहीं हो गया है
ऑर्डर कंप्लायंस हो गया तो फिर आपको क्यों ही अपने पेरेंट्स टाइम
लॉजिक एब्सेंट मार्क कर गया तो आई हैव टोल्ड हिम दैट आई विल लेट
लॉस चलिए